Good afternoon, Your Honor.
Good afternoon. Who are we ready on?
Mr. Schmidt is on Zoom. He's already been out here and done his resets, and so if you'll bring him in, we'll start with his.
All right, who do we have first?
Seth Atkins.
All right, court calls State of Texas versus Seth Edward Atkins, CR 22-368. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, we'd ask to set Mr. Atkins on a plea on your next docket.
All right, court sets Mr. Atkins enters plea for court September 16th, 1:30.
Thank you, sir.
Who's next?
This is Brendan Creel.
Court calls cause number CR 23-158, CR 24-206, 2025-92, 2025-98, State of Texas versus Brandon Ashley Creel.
And Judge, just for the court, to remind the court, there are we have the motions to adjudicate Mr. Creel's probation, but we have indicted new offenses. I filed a notice of intent to seek the insanity or to allege the insanity defense on those new cases, and they may trickle down to the MTA. I've made Ms. Curry aware of it, and we've had a brief contact about how to resolve that. The state is entitled to an expert evaluation. As far as I know, that has not occurred as of yet, but I anticipate meeting with Ms. Curry or speaking with her again pretty shortly to see if we can't come to a resolution that doesn't take forever.
Did you say this is on the newly indicted case?
That's correct.
It's not set on docket today?
I don't see it, but it should be, because we've been running those together. I think we've arraigned him on that. There was a point in time where Mr. Creel was deemed incompetent in this most recent process. It's been a little while.
Your Honor, I believe it may be that CR 24-206. It's labeled as MTA MTR, but if memory serves, I think it's the burglary.
I agree with that.
So what cause number is it?
CR 24-206, Your Honor.
All right, how much any announcements from state?
Nothing from the state, Your Honor. We'll get with Mr. Schmidt and start coordinating whatever needs to be coordinated.
All right, court will set this on Tuesday, October 14th. Status. Who's next?
Keith Eddington.
Court calls Keith Allen, CR 20-132, motion for vote. Go ahead, Mr.
That's correct, Judge. I think there is a new offense as part of the basis for the motion to revoke. I think we're going to be able to resolve it, but we'd ask for one additional setting on that. We're likely to plead on that date.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Eddington then for test the docket on October 2nd.
Next will be Roy Hamilton.
State of Texas versus Roy Lakeenan Hamilton, CR 21-71, motion to revoke. Go ahead.
Judge, I think we're right on the cusp of a resolution. I'm confident enough to ask you to set him for a plea on 9/16.
All right. Any objection from the state?
No objection, Your Honor. Thank you.
All right, court says Mr. Hamilton for plea September 16th, 1:30.
Alexis Nava.
Court calls State of Texas versus Alexis Nava, CR 20-185, motion to revoke. Go ahead, Mr.
Judge, I've been recently appointed on Mr. Nava's case. I briefly spoke with him today. I'm going to ask for an additional reset.
Any objections from the state?
None, Your Honor. Thank you.
Court says Mr. Nava for October 2nd. 1:30. Are you waiting, Ms. Abraham, October
Sir?
2nd? Are you waiting, Mr. Nava, to reset to October 2nd?
Judge, I think that the only other inmate that's on your docket that belongs to me is Tricia Inglesby. I spoke with her through the glass in the gym when I was over there. I think we've resolved her I don't think she's in there. So we're gonna
They went
ask her.
to get her.
She's in the gym.
All right, court calls cause number CR 18-318, State of Texas versus Tricia Lee Inglesby, motion to revoke. Go ahead, Mr. Schmidt.
Judge, I think we've pretty much reached an agreement. I'm gonna ask to set her for 9/16 for a plea.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court says Ms. Inglesby for a plea on September 16th.
I'm sorry, please. Okay, thank you. Thank you. Yeah. Oh, well, it's hard to find Satan. After find people, spiritual warfare, we pray to in the world. We love y'all.
Is that all you have, Mr. Schmidt, to say?
I think so, and I'd like to thank Ms. Abraham for getting those signed in for me.
All right, not a problem. Thank you, Mr. Schmidt.
Thank you. Have a good day.
Who's ready? Mr. Manning ready? Or is he still working?
I'm ready, Judge. Well, we're still waiting paperwork from Mr. Windsor. But other than that, I can do the remainder of my cases.
Who would you like to call first?
Let's start with Mr. Harrison.
State of Texas versus J. Randall Harrison, CR 24-137, motion to vote. Go ahead.
Yes, sir. Mr. Harrison was on the docket. Looks like it's assigned to both Mr. Schmidt and I. I am representing Mr. Harrison and have spoken to him previously. However, I've not received an offer to resolve his case. I did get some mitigation documentation from Mr. Harrison today that I plan on copying once I get back to the office and providing to the state in their consideration of an offer. I'd request that he be set for the next contested docket so we can get his case resolved.
You're saying that you show that I've appointed 2 attorneys to Mr. Harrison, you and Mr. Schmidt.
Judge, on my docket, at least it shows that Mr. Schmidt is the first attorney and then I'm the second attorney. I believe that Mr. Schmidt represented Mr. Harrison on the original charge.
Yes.
And I'm representing him on the revocation.
Okay, I don't have that on my docket at all, but court will reset Mr. Harrison for additional hearing on state's motion to adjudicate. We'll set that. You'll set that October 2nd. That's the next evidentiary date, or do you think you'll have it resolved without a contested hearing?
Judge, if we get a resolution, I will ask for a sooner date. I anticipate we should be able to do that once I speak to the state.
Very well, Mr. Harrison said October 2nd. Go ahead, Mr. Trumbull.
And Mr. Manning, I apologize. I sent an offer to Mr. Schmidt. I had the same confusion, so I'll get that over to you. Should be today.
Thank you. And I'll send you the stuff that I have as well.
Thank you, sir.
Who's next?
Next we have Mr. Shoemaker.
State of Texas versus Christopher Reagan Shoemaker, CR 23-74. Motion to revoke. Go ahead.
Judge, we received an offer on Mr. Shoemaker's case, and my client is interested in taking it. However, he would like to confirm his back time credit before we finalize that. So if we go ahead and set him for a plea at the soonest possible docket, or the next possible docket, and then I will get his back time credit and go over that with him.
All right, court will set Mr. Shoemaker for plea September 18th at 1:30. Who's next?
Judge, next we're ready on Mr. Parks.
State of Texas versus Joseph Leon Parks, CR 22-192. Mr. Parks, entering the plea today.
Yes, Judge. And before we begin, there were 3 counts. All of those were new offenses out of Hunt County. And my understanding through communication with other parties besides my client was that he had resolved all of his business in Hunt County. And I took that to mean that he had pled or been found guilty of those offenses. When in fact, it appears that they took the other 2 counts into consideration. I don't believe this him being true to those counts would put him at exposure for anything as those cases have already been resolved as part of his plea from Hunt County. But out of abundance of caution, if we could withhold our plea on those 2 counts, I don't know if that would cause any problems with the state based off of their offer of the time served to be taken today.
It wouldn't change the negotiation at all. It would just require reforming the judgment, which would take about 15 to 30 minutes, depending on how quickly we can get the technology to cooperate.
Okay.
Let me ask, so which counts? So there's only 3 counts.
Correct.
And which of those counts are you saying that he would plead true to?
He would plead true to count 1, the evading arrest.
With the main risk, and then I had 2 misdemeanors that played true to, but not the unauthorized use.
Not that
That was on 1.
Okay, is that y'all's agreement? Is that what y'all want to do, Mr. Hartwell?
Yes, Your Honor. State's fine with amending it to being count 1 and then abandoning 2 and 3. It'll just take some time. We'll work on getting those papers done.
All right, so go ahead and have a seat. We'll call you back up when the papers are done.
Thank you, Judge. Next, we're ready on Mr. Rosman Shannon.
Court call CR 20-363, State of Texas versus Rosman Renee Shannon.
State's ready.
Is this a plea today?
Yes, Your Honor.
All right, Mr. Shannon, if you will raise your right hand, I'm gonna place you under oath. You swear that the testimony you give for today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. All right, Mr. Shannon. Paperwork here. All right, it appears that you were before this court on June 29th of 2023, which you pled guilty to the offensive assault of a family or household member by impeding breath or circulation in third-degree felony. The court heard the evidence and the plea agreement. Court followed the plea agreement, assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and also ordered you to pay a $2,000 fine. Court, part of your plea agreement, suspended the sentence and placed you on community supervision for a period of 5 years. During that period of community supervision, the state has filed a motion to revoke your community supervision, and they have alleged 7 separate allegations of violations. Have you had enough time to review the state's motion to revoke with your attorney, Mr. Jonathan Manning?
Yes, sir.
You understand everything that you have read and signed as part of your plea agreement today?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
Mr. Manning, do you believe your client's competent in their agreement?
I do, Judge.
And you've explained to him his rights as they regard this case?
I have.
And do you believe he is entering into this intentionally, knowingly, and voluntarily?
I do.
Does your client waive the formal reading of the state's motion to revoke?
He does.
Does he intend to plead true to specific counts or all counts?
All counts in this case, Judge.
Okay. All right, Mr. Shannon. This time I would ask you, how do you plead to counts 1 through 7 as contained in the state's motion to revoke? Are those counts true or not true?
True.
And you're telling me that each one of those counts is true because what is alleged is actually true. You're not just saying that to get a plea agreement.
Yes, sir. They're actually true.
And Mr. Shannon, has anyone threatened you, forced you, or pressured you to plead true to any of these counts?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights to plea of true?
No objection as offered.
That is admitted into evidence, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state, Mr. Hall?
Your Honor, just to be sure on the days, as of yesterday, we'd calculated 200 and yesterday would have been 255th day. We had calculated 254 earlier. So I think 255 would be the correct number of days for him to be credited with back time.
You agree with that, Mr. Manning?
Yes, Judge.
Okay. All right, and so before I go any further, Mr. Shannon, I see the agreement in your case is the state is recommending that your community supervision be revoked. The punishment be assessed at 5 years confinement in prison, along with you paying the previously ordered fines, court costs, and reimbursement. That's your understanding of the plea agreement?
Yes, sir.
And of course, you would receive 255 days credit towards that sentence for the time that you have spent in jail on this cause.
Yes, sir.
Okay. All right. Understanding those things, then court hereby finds that Rosman Renee Shannon has violated the terms and conditions of this community supervision. Court finds that there is a plea agreement. The court will follow the plea agreement. Court hereby revokes the community supervision of the defendant, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations for having found all counts to be true as alleged. The court also orders Mr. Shannon to pay previously imposed financial obligations of fines of $2,000, court costs $40, and reimbursement fees of $140. And the court awards Mr. Shannon 255 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Shannon, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of his sentence. I'm gonna have you step over and be fingerprinted. Mr. Shannon, once you are released from TDC custody, if you've not paid off your fines, fees, court costs, I'm gonna order you to report to the Van Zandt County Courthouse. Go up and speak with the district clerk's office and see if you can set up a payment plan to take care of your obligations. Failure to do that could result in a warrant being issued for your arrest.
And Judge, I explained that to him. Explain that to him as well.
Thank you, Mr. Manning.
I'd be excused, Your Honor.
Yes,
Thank you.
that door's locked.
I'll go around the other way.
Just make sure that. Mr. Manning, who's next?
Next is Mr. Ready on Mr. Ulibarri.
Court call CR 24-155, State of Texas versus Patrick Dennis Ulibarri. Mr. Ulibarri, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You don't worry. In just a second here, let me review your paperwork.
Hey.
All right, Mr. Ulibarri, it appears that you were present in court on December 5th of 2024. You pled guilty to the Class A misdemeanor offense of assault causes bodily injury of a family member. On that date, the court considered the evidence and a plea agreement that you reached with the state. Court found that there was enough evidence to convict you of the offense. The court, part of your plea agreement, deferred the finding of guilt and placed you on community supervision for a period of 18 months. Court also assessed a $250 fine. It was during your period of community supervision that the state filed this motion to adjudicate and revoke. And in that motion, they alleged what appears to be 7 separate violations, allegations of violations. Have you had enough time to review that motion with your attorney, Mr. Manning?
Yes, sir.
And I understand that you have a plea agreement in this case, and upon you pleading true to the counts in the allegation, you're pleading true to counts 4, 5, 6, and 7. Upon the court hearing those, the state is recommending that you be adjudicated. That means that you be convicted of the offense, and that your community supervision be revoked. That you receive a sentence of 98 days in the county jail, with you receiving credit for. I'm sorry, I said 98. The sentence would be 93 days, with you receiving credit for 93 days of time served. Also be ordered to pay the balance of your fines, court costs, and reimbursement fees. Those being a $250 fine, $270 in court costs, $935 in reimbursement fees. Mr. Ulibarri, is that your understanding of the plea agreement?
Yes, Your Honor.
Are you pleased with Mr. Manning and the work that he's done?
Very much.
Do you have any questions about any of the paperwork that you've read and signed?
No, Your Honor.
Mr. Manning, do you believe Mr. Ulibarri to be competent? If so, that he's entered this plea intentionally, knowingly, and voluntarily?
Judge, I do believe him to be competent. And I believe he's entering into this plea intentionally, knowingly, and voluntarily.
And does he waive the formal reading of the state's motion?
He does, Judge, and per agreement, we are only pleading to the technical violations, as the other violations are still pending and unfiled at this point in time.
Are those Van Zandt County allegations or somewhere else?
They're Van Zandt County allegations.
All right, understanding the motion, Mr. Ulibarri, and also the plea agreement. This time I would ask you, how do you plead to counts 4, 5, 6, and 7? Are those counts true or not true?
True.
Are you pleading true to each one of those because what is alleged is in fact true?
Yes, Your Honor.
And sir, has anyone threatened, force, or pressure you to plead true to any counts?
No, Your Honor.
All right, the court will accept the defendant's plea of true. The court also admits the defendant's waiver of rights, plea of true and evidence. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Nothing on this, Judge. We do have additional matter to take up after we finish the plea, though.
Okay. All right, then the court, having considered the evidence, finds that defendant has violated the terms and conditions of his community supervision. Specifically, the court finds counts 4, 5, 6, and 7 to be true. Therefore, the court is revoking the community supervision of the defendant. The court follows the plea agreement. Court adjudicates his guilt, convicts him of assault that causes bodily injury of a family member, assesses the sentence at 93 days confinement in county jail, awards Mr. Ulibarri 93 days credit towards the sentence for the time that he spent in jail on this cause, and orders him to pay the balance of his financial obligations previously announced by Mr. Ulibarri hereby remanded to the custody of the sheriffs to carry out the terms and conditions of the sentence. Mr. Manning, let's go ahead and bring up whatever issues you want to talk about.
Yes, Judge. So I today was able to take a look at the most recent indictment list, and Mr. Ulibarri was originally arrested on this offense on May 10th, 2025, and has been in custody 100 days, approximately 100 days on these two new unindicted cases. And so our request would be that he be given a personal bond on those two cases until so that he may get out, continue to work, prepare for his defense on the two new cases.
Are you representing him on the unfiled cases?
Judge, I believe I was reappointed to represent on those new cases as well. Yes, Judge.
All right, so I prefer you just go ahead and follow your motion. That way the state has an opportunity for notice and to be heard.
Absolutely, Judge.
All right, Mr. Ulibarri, I'll have you step over to be fingerprinted with the deputy. Once you are released, you need to report to the courthouse to make arrangements to pay off your fees.
Okay.
Next, okay.
Judge, I believe we've got the correction made on Mr. Winger's paperwork, so if I may have a couple minutes to do his and get Mr. Park's paperwork corrected, then we should be ready to wrap up those two and have our hearing on Mr. Cromwell.
Okay. All right, court will send it to you.
And Mr. Manning, Mr. Park's paperwork should be headed on its way over here in just a moment.
Excellent, thank you.
All right, court will stand recess.
Your Honor.
Yes, ma'am.
And then we'll still have Mr. Hagel, and what I'm told from the jail staff is he has not retained an attorney yet. He's still waiting on the money from his grandfather. So
Well, let's bring him up and we'll have a discussion.
and we'll have to do him last. He can't come in the last.
Understand.
Your Honor.
Yes, ma'am.
Okay, we have Mr. Hagel.
All right, court calls cause number CR 24-232, State versus Michael Tanner Hagel. All right, Mr. Hagel, give me an update on where we are in you hiring your attorney that you requested.
Well, on the new cases, my granddad hired Nolan Why. I thought this last case I signed for the MTR or the MTR that I have, I thought it was still Richard Smith from the last time. I thought this new one was for my new 3 cases I caught.
You're gonna have to explain that to me again. I'm not sure.
Okay. So my MTR, the one that I'm here on right now, I thought my attorney was still Richard Smith from the last time. My granddad hired Nolan White.
You mean the last time you got a motion to revoke?
Yes, because I'm here on an MTR right now, right? That's what I'm here for, the MTR.
Right, yeah, so Mr. Schmidt, he doesn't stay your attorney the whole time you're on probation.
Oh, I didn't know. So I didn't know that. I thought that my
No,
granddad hired.
Listen, listen, you gotta, once you resolve the case, then you don't have an attorney anymore. So then a motion to revoke was filed. That's what we're here on today. That's what we were here on in court last time. That's what you're supposed to be hiring an attorney to represent you on. Now go ahead and tell me what you want to tell me.
Okay, my granddad hired Nolan White for these 3 new cases. My possession of controlled substance, the evading arrest, and failure to identify as fugitive. That's what my granddad hired Nolan for. I didn't know that it was for the MTR. I thought I thought Richard was still my one from the MTR.
Okay,
So that was my misunderstanding. I didn't know that that's how it worked. That's my misunderstanding.
so are you gonna hire Mr. White to represent you on the TR also?
I'm gonna have to talk to my granddad about it because we just paid him $6,200 for my new cases.
Yes. Okay. You want me to give you one more reset so you and your grandfather can figure out? If that's
Yes, sir.
Okay.
Yes,
How
sir.
how long will it take you, Mr. Tanner or Mr. Hagel? I don't wanna leave you in there.
I'll call my granddad as soon as I get back today and see if he can work something out with Nolan White on this MTR too.
All right, I'm gonna reset you to the 18th. September. And then if Mr. White is going to represent you, then he'll know what to do.
All right, thank you, sir.
Thank you, sir.
You're welcome. All right, Mr. Manning, are you ready?
Judge ready on Mr. Parks.
I don't have any paperwork parts yet, so I'm gonna have to wait till I get those.
Okay, Judge. We can do you have Mr. Winter's paperwork?
And let me refresh it. Yes, let's do Mr. Windsor.
Okay.
All right, court calls CR 25-58, C and FC 25-14, State of Texas versus Demetrius Windsor. Mr. Windsor, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can already.
Judge, and if, I apologize. There was one issue that was brought up by probation that we felt like should probably be addressed beforehand. Mr. Windsor has a current court case out of state, and the court's policy is not to permit travel. However, this is a new issue, a novel issue that I've not come across in the past year of the court's new policy. And so we were wanting to get some direction before we begin as to if documentation is provided of specific court settings in another jurisdiction, if the court would permit travel to attend those court settings as they are pre-existing the plea today.
I do not believe that absolve me of any personal liability should Mr. Windsor commit a crime in another state while he's on felony probation in the state of Texas. I believe another court having or requesting him to be present is going to absolve me of the liability that I would be exposed to. So I would not grant a travel pass. I will not grant a travel pass in any scenario for anyone on felony probation unless that person is being transferred according to the interstate compact, which is provided by statute. And then I don't grant travel passes for that until that process has been completed. So if Mr. Windsor is going to have issues in another state that he's going to have to tend to, and if he doesn't tend to them, going to result in being a wanted person, then perhaps this plea agreement today is for probation is not in his best interest.
So I just to be clear, the court is overriding the jurisdiction of any other state or court by excluding travel to attend those court settings under their conditions of probation.
No, I'm not overriding any other court or any other jurisdiction. I'm simply limiting my personal liability because I do not have the authority as a district judge in Texas to authorize interstate travel outside of the statutory framework provided in the interstate compact. Therefore, if Mr. Windsor is a felony probationary in the state of Texas, if he leaves the state, he will be in violation of the court's order. And if I as a judge allow Mr. Windsor to knowingly enter across state lines into another state, then I'm allowing him to violate and I personally would be violating the state compact, which would then cause me to shed my judicial immunity that I have. So it's not that I'm usurping any other court's jurisdiction. If they want him, they can issue an order and they can come and pick him up or do whatever they want to do, but that would not be me granting him permission to travel into another state in contravention of the interstate compact.
So, Judge, if a subpoena was issued for his appearance in court, what remedy would my client be left with? Because he would be forced to either disobey the order of the court or to violate his terms of probation here.
Well, you presented the court with apples and oranges. You began by saying if Mr. Windsor provided the court with court dates, could he go? Would I, as a Texas district judge, allow him to go? But now you're asking me if he is being subpoenaed, which is legal compulsion by another court. So those are two different things. I would have no liability because I would not be granting a travel allowance. And he would have a defense to any kind of violation. He's being legally compelled to be in another jurisdiction.
Your Honor, if I may just speak briefly to my client about any questions that may have arisen from this and see what he would like to do. If I could just have just a minute.
Yes, sir. Good.
Judge, after speaking to Mr. Windsor, he believes that it would be in his best interest to go forward. And he will be able to get the necessary orders from the court in Louisiana to require his appearance there. And with the understanding that the court has provided, he believes that will be a sufficient way to proceed in this case, and he would like to go forward with the deferred probation.
Okay. All right, Mr. Windsor, your name is Demetrius Windsor, is that correct?
Yes, sir.
And your middle initial is N, is that correct?
Yes, sir. Nathaniel.
Nathaniel, it just says N on your paperwork, so. Mr. Windsor, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir, I am.
Do you have any questions about the paperwork that you've read and signed today?
No, sir.
All right, Mr. Manning, do you believe Mr. Windsor to be competent, and if so, that he's entering into this agreement intentionally, knowingly, and voluntarily, and that he also understands the advantages and disadvantages of deferred adjudication plea?
I do, Judge, and I have gone over those with him.
All right, Mr. Windsor, in CR 25-58, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that carries a range of punishment of not less than 2 years in prison and not more than 10 years in prison. Should you be convicted and sentenced, that would be the range of punishment which the court could assess your sentence. I see that there is a plea agreement in your case. Upon you pleading guilty to that offense, the state is recommending that the court defer a finding of guilt. That means not convict you of the offense at this time, to place you on 5 years community supervision, order you to pay a $2,500 fine, $290 in court costs, $655 in reimbursement fees. And as part of the agreement, the DA's office is asking the court to dismiss the other indicted case, FC 2514, which is a forgery of the governmental or national instrument of security. In addition, you would have to serve 60 days confinement in county jail. You would receive credit of 41 days towards that 60 days. You would have 19 days left to serve as a condition of your supervision. And it appears that you have reached an agreement also with the state on when you would submit yourself to the Vincent County Jail to serve the remainder of those 19 days. Mr. Windsor, is that your understanding of the plea agreement?
Yes, sir, it is.
All right. Understanding those things, I'd ask you, Mr. Windsor, how do you plead to the third-degree felony offense of evading arrest or detention with a vehicle?
Guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir, I am, sir.
And Mr. Windsor, has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir, they didn't.
All right, court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the evidence?
No objection as offered.
All right, evidence is admitted in stipulation. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will review the evidence. All right, court, having reviewed the evidence, finds this to be enough evidence to convict the defendant of the offense. Court this day follows the plea agreement. Confers the finding of guilt on the third-degree felony offense of evading arrest or detention of the vehicle. Places Mr. Windsor on 5 years community supervision. Orders him to pay a $2,500 fine. Also orders him to serve 60 days confinement in the county jail. Court gives Mr. Windsor 41 days credit towards that sentence. Orders him to serve the remaining 19 days as a condition of community supervision also. As outlined in State's Exhibit A, for which the defendant will submit himself to the Van Zandt County Jail. The court dismisses under Section 1245 the forgery charge in FC 25-14. Further, the court orders Mr. Windsor pay court costs of $290 and reimbursement fees of $655. Mr. Windsor, you're hereby remanded to the custody of the probation department so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted with the officer and then you'll be with probation. And Mr. Manning, I think I have Mr. Parks now, so if you wanna go ahead and bring him up, once I sign these, we'll get started.
Thank you, Judge.
Mr. Manning, remind Mr. Windsor, I forgot to do it, remind him that he'll need to appear with a photo ID and a copy of the commitment order when he's to serve his sentence. Otherwise, I'm not gonna let him in.
Yes, Judge.
All right, Mr. Parks. This is cause number CR 22-192, State of Texas versus Joseph Leon Parks. Mr. Parks, have I placed you under oath yet?
No, sir.
You'll raise your right hand, sir. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. All right, Mr. Parks. Just one moment. Get your paperwork pulled up. All right, Mr. Parks, you appeared before the court on July 5th of 2022. On that day, you pled guilty to a state jail felony, unauthorized use of a vehicle. The court assessed your punishment at. Have a second to review paperwork here. I'm not sure. This is this enhanced offense?
Yes, Judge.
Was okay. It was a state jail enhanced to a third,
Yes. Sorry, second. Yes, Judge.
to a second. Okay, Mr. Parks, you appeared in the court, heard the evidence on that offense. And court found that there was a plea agreement between you and the state. Court followed that plea agreement. Court assessed your punishment at. Is this not a deferred?
No, Judge.
This was a straight. The motion says 10 years state jail, but that's not, it can't be.
Try what?
The state's motion says that punishment was assessed at 10 years confinement in the state jail division of TDC. That's just the type of.
I believe that the underlying plea was to the lesser, or to the original offense of the state jail. That's just going off of my memory. But I believe I believe I represented Mr. Parks with the original, and we got it down to a state jail.
No, it was 10 years, probation with a cap, so, cause it was regular probation.
I want to share my screen so I can show you the issue that I see. Mr. Parks was convicted of UUMB, second degree felony, 10 pro 10. So what you are proposing today in the plea agreement is not legally available to him. As a 1244A, it's no longer a state jail felony.
And Judge, I apologize. I received the offer from the state yesterday, and I was not at my office. I assumed that was within the range of punishment, based off of the offense as listed and my recollection of my client's case from back then.
And Your Honor, it was my understanding that since the underlying was a state jail, that was based on enhancements, that it could still be punished under the standard state jail range. Additionally, it appears from the judgment that we failed to request findings on the enhancement punishments that would have made it punishable under a second degree.
Let's reset Mr. Parks and let's dig into this, make sure that we're legally correct on it. So Ms. Robo, you think that we still extend it 1244B or 1244A?
Yes, Your Honor, that was my understanding. But I'd have to dig back into it to see where I came to that understanding.
Okay, let's reset Mr. Parks, because I'd like to review the law on that. If Mr. Parks can be convicted of a second degree felony but punished as a misdemeanor, then I need to see the bill people.
And Judge, in speaking to Mr. Parks, if we need to, he has, I believe, sufficient back time credit due to his successful completion of SafeP, as well as his time down in TDC. I think he gets sufficient time to cover the minimum of a TDC sentence if we need to. So if we want to do a short reset, I'm sure we can get this resolved one way or the other.
Okay. Let's see, because today we're going to do time served. Is that right?
That's correct, Judge. Just as in an effort for him not to have to sit and wait, catch chain. The hope would be that he'd be able to get out more quickly back to TDC. He's been bench warranted up here, which is why he and I didn't have an opportunity to discuss this before today.
Do you two want to discuss that? Meaning you and Mr. Harwell, do y'all want to discuss reforming the plea to something that is in line with his second degree felony?
We can, Your Honor. State wouldn't have an issue with doing that. On any reform judgment, would the court need to make findings on those enhancement paragraphs, though?
I believe we would.
Judge, I'm fine with resetting. I was just presenting additional options if we're unable to find a legal means. My client and I are willing to work with and continue negotiations. As I said, I just received the offer yesterday, and in an attempt to be judicially efficient, I probably went faster than I should have and not looked at the prior judgment.
Okay, and I don't. Judge Winters and I are both out next week at the judicial conference, so the earliest I could get to him on my regular docket, Mr. Manning, would be the 18th.
Judge, that'd be fine.
Okay. And you're gonna explain to Mr. Parks what the issue is?
I have, and he is willing to wait that additional time to get everything done correctly.
Okay. All right, then the court will reset Mr. Parks for plea on September 18th at 1:30.
Thanks, sir.
You're welcome.
Oh, yes.
Yeah.
Mr. Hartwell?
Yes, sir.
I have a plea for Wade Mathis. I don't see Wade Mathis on my docket. Do you have Wade Mathis on yours?
I don't today, Your Honor. I'm familiar with the name.
And maybe Sammy's just sending it to me early, but I wanted to make sure that I wasn't overlooking someone.
That could be, Your Honor.
Okay, very well. Mr. Manning, you ready on Mr. Cromwell, or do you have anyone else?
Judge, I believe Mr. Cromwell is my final client. Would you like for us to set up a table so that Mr. Cromwell and I can sit, or you want us to just stand at the podium?
No, you can set up a table to where you can sit.
Okay. If I may just have just a moment.
Yes, sir.
Does it go down?
Back up. You're good.
It's just not staying.
Yeah. Oh.
Does that work?
Good work.
Oh, cockeyed.
Probably have to be close. Judge, is that okay?
Yeah, that's
All right, he's fine. Just keep up, okay? Right. Use your outside folks.
Yeah, we have to scoot down just a little bit.
Right there.
all right. Court calls cause number CR 24-309, State of Texas versus Philip Shane Cromwell. So that we are set today. Mr. Cromwell is specially set for jury selection, I believe, February 9th of 2026. Court finds that counsel has filed a motion to withdraw. Mr. Manning, go ahead.
Judge, this was an agreed motion that was filed on behalf of my client. And so I believe that Mr. Cromwell and I have attempted to negotiate our differences, but irreconcilable differences have arisen between the two of us, and I'm despite our conversations, yet unclear what the nature of his dissatisfaction or differences are at this time. I think that's part of the communication problem that we faced. I will present evidence, but I guess at this point, I'd turn it over to the court and Mr. Cromwell to hash out what the perceived issues are.
Cromwell, I'm gonna have you testify for a limited purpose of your agreed motion to withdraw. Mr. Manning is counsel. Raise your right hand. So you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, so Mr. Cromwell, I'm gonna allow you to testify in just a moment. I will caution you that you should not say anything that can be used against you in this prosecution. You also should not divulge any attorney-client privileged information. If you divulge it, it can be used against you. There's no longer a privilege there. If you divulge it to the prosecution or to the court or anyone that's even within hearing, you understand those admonishments? Okay. All right, so you've heard Mr. Manning state that he's filed this motion based on irreconcilable differences, yet he's not real clear on what your concerns are. Why are you asking the court to allow Mr. Manning to withdraw?
Your Honor, we just never got along, and when I first filed agreements on him for lack of communication, he come up here and he made a verbal threat to me, and the verbal threat was pretty serious, that I would receive the worst counsel in Van Zandt County and I would go to jail. He had that kind of power. And so I withdrew my grievance, and then after I withdrew my grievance, I prayed about it, and they just told me my mind told me to do it again. And then not only that, but when I come to court trying to make a bond, I asked for a bond reduction. He said he would give me one. And then when I come to court, he laughed right in my face and said, "I thought you were getting out." You know, and just we haven't got along since the beginning. He laughed in my face. He threatened me. I mean, it's better for us to be terminated.
Do you intend to, if I grant this motion, do you intend to hire an attorney to represent you?
No, sir. I was hoping that you could appoint me another.
Well, there's only 2 attorneys here in Van Zandt that I have appointing authority over right now, and one of them sitting to your right.
Okay.
Do you have the ability to hire an attorney?
No, sir. I've been trying to.
And how have you been trying?
I've been my house is on the market right now. Been trying to sell it.
How much is it worth?
It's worth $25,000.
How long has it been on the market?
It's been on the market since I've been here 10 months.
Okay. So you're telling me that you want him to withdraw because you don't get along, and that he's made a verbal threat to you regarding representation of counsel, and that he laughed in your face. Is that right?
He hasn't been diligent, courteous, nor prompt with anything with me, sir. And I know that's part of the creed that y'all take there. It's my case to him is a big joke. I've received PTSD from this traumatic accident I've been through right here, and he never once took in my mental state. You know what I mean? My mental state is very bad from this accident that occurred, and he never once took any of that into consideration, sir. I mean, I'm bad off. I'm not very well mentally right now.
Do you believe that you need mental health services?
I've been receiving them here.
What kind of services have you received?
The Andrew Center started coming up, seeing me and talking to me. They put me on medication so I could sleep, because the accident consumes every waking thought, and what consumes my every nightly thought when I dream. You know, I think about the accident.
And you said that you filed 2 grievances with the state bar against Mr. Manning?
Yes, sir.
And what did you allege in your grievances?
I told just what it was said there, the thread about what he done, and just the promptness and diligence and courteousness. We never got along from day one.
Well, You don't have to get along with your attorney for the attorney to provide competent legal representation. If you want to get along with an attorney, then you're going to need to hire the attorney that you want to get along with. So getting along is not a legal standard that the court takes into consideration at all. Okay.
I'll pull the grievances if I need to. I mean, I thought the grievance program was supposed to put us in a client attorney relationship program to fix our problems. That's what it said. It said if you file agreements, then you get put into a program where your relationship is fixed. I just figured he was going along with the threat that he made to me about dropping you and you'll reserve the worst counsel in Van Dyke County. So I figured that's what it was going along with it. You know what I mean?
Mr. Manning, would you like to respond?
Yes, Judge. I'd like to start by having the court take judicial notice of the court's file regarding this case. Specifically that I was appointed to this case on November 14th of 2024. At that point in time, after I was appointed to this case, I requested any initial probable cause affidavits or police reports immediately. And I met with Mr. Cromwell on November 22nd of 2024, which I showed to be 8 days after the appointment. I received the initial documents from the Van Dyke County Discovery Portal on November 21st, and on the 20th, which is what I was waiting for. Before going to visit with Mr. Cromwell on the 22nd at the Van Dyke County Jail. The District Attorney's Office timely indicted the case on December 20th, but discovery was not made available until January 2nd of 2025. Besides my initial contact on November 22nd, I have, outside of the court setting, visited Mr. Cromwell a total of 5 times. During that period of time, and have appeared with him in court each time he's been set. We've not requested any continuances or resets. In fact, at Mr. Cromwell's request, I asserted his right to speedy trial, and this court denied the request due to the state not having all the discovery ready at that point in time. Additionally, this court denied an agreed bond reduction that was negotiated with the state at Mr. Cromwell's insistence. And as the court noted before, we were specially set for trial on February of 2026. Judge, I would also note that in the initial grievance that was filed, that was referred out to the Client Attorney Assistance Program under case number 1013607. As a discretionary grievance referral, which was numbered 202-503-267. And I received note from the State Bar of Texas on July 8th of 2025 that such action was been taken by Mr. Cromwell against me at that time. I was later served with a copy of a grievance that contained some of those accusations, and that was dated June 4th of 2025, and was notified in writing that would be referred out to as a discretionary referral. I received a letter subsequently that the grievance referral was resolved and dismissed after I had made contact with, as Mr. Cromwell said, made contact with Mr. Cromwell on Thursday, June 19th. He conveyed to me through family members that I've been in communication with throughout his representation that he was ready to move forward with my representation and withdrawing his grievance. At that point in time, we went over discovery, additional discovery that had come to light since our last court setting, and he confirmed that he was ready to move forward at that point in time. I then received a letter on July 30th, which was under the same reference number for the previous grievance, and was also given a Board of Disciplinary Appeal case number 71506, which stated that Mr. Cromwell at that point in time was appealing the dismissal of the grievance, and that has been referred out to action by the board and review from the board. In response to the allegations that Mr. Cromwell has presented today, I would like to briefly call him and question him on some of those issues and provide evidence to the court.
Maybe see.
Thank you, Judge. Mr. Cromwell, isn't it true that you were arrested on this case in November of 2024? Is that correct?
Yes, that's correct.
And I was appointed to your case on November, I believe it was 14th of 2024, and visited you for the first time on November 22nd of 2024.
That's indeed correct, sir. You didn't visit me until December.
So if I were to go pull the records from the jail as well as communications, and possibly if they still have it, the video footage, you're saying that it would not show that I came to you on November 22nd, 2024, to visit with you on the initial intake of your case. Is that correct?
I do not remember. It's been too long.
Okay. Isn't it true that I also came and visited you on December 13th of 2024, following up from our previous conversation and updating you as to the communications that you sent me, both from your family, from your jail phone call and jail mail, that I came to visit you on December 13th of 2024. Is that correct?
I do not remember.
Okay. And would you contest that if I said that I visited you on 12/13/2024, would you contest that was true?
I suppose it is.
Okay. Additionally, on February 6th, 2025, I came and conveyed additional information and discussed your questions and concerns about the case. And I believe at that point in time, we went over some additional discovery that had been provided by the DA's office. That had been released some photos. And it was at that point in time that you stated that you did not wish to view the photos because they were too disturbing. Is that correct?
It was not at that time. No, they didn't get the additional discovery until just a couple of months ago.
So you're saying that we did not visit on February 6th of 2025, or we did not go over the
We did not go over discovery.
we didn't go over the additional photos?
No, they didn't have no discovery yet. You told me that they had no discovery to indict me on.
Isn't it true that I also came and visited you on May 9th of 2025? Is that correct?
Don't recall.
Okay, would you contest that I visited you on May 9th of 2025?
I know you came May 1st.
And I'll get to our court dates. I'm talking at this point, I'm only talking about my visits to you here at the jail outside of our normal court appearances.
Yes, I was in the visitation area. You come May 1st.
No,
August,
May 9th.
April 29th. Come visit me. I wrote it down. I was never there.
Right now I'm referring to May 9th. Do you recall that visit?
No. Okay. Yes, I do. Yes, I do. Because you told me that they had an offer for me.
Okay. And that's correct. That I did convey the offer that had been made on May 2nd. I conveyed that on the May 9th. Isn't it true that I also visited you on June 20th of 2025? Is that correct?
I do not recall.
And that was in response to your client, to your families reaching out to me on June 19th, stating that you were ready to move on with your case and put our differences behind us. Is that correct?
Yes.
Okay. And then additionally, I came and visited you on August 4th, 2025. Is that correct?
to follow,
To get your signature and discuss the motion to withdraw.
to drop me, yeah.
Yes, okay. So you confirm that of those 7 times I came to visit you here at the jail outside of the court, is that correct?
I don't believe it was 7 times, no, sir. I believe
Okay.
it was more like 6.
But we just walked through each and every one of those and you
But I
still,
don't believe one of them were correct, no, sir.
Okay.
So I got it wrote down too, but I don't know I was gonna be put on trial right here. I would have brought my paperwork with me. So every time I have send paperwork out or have a date outside, I write it down. I didn't know you're gonna take me to trial and I have to represent for myself right here.
we're not in trial, we're simply on a hearing. And do you recall the first offer that was made in this case?
It was 2 to 20. 2 to 20, and that was on, what, August. May 9th, you said?
May 9th, that's correct. So you understand that you're charged with murder, which was indicted as a first degree felony, 599 or life. You understand that?
Yes, sir.
And the first offer that I conveyed to you was 12 TDC on a manslaughter case. You understand that?
You told me just 2 to 20. That's all you told me.
That was in the manslaughter is within that range.
Okay.
Yes. Additionally, after you filed your first grievance and after we discussed your discovery on June 20th, I received an additional new offer, which I conveyed to you on August 4th when I came to file my withdrawal. Is that correct?
Yes, you briefly run it by me on the way out.
Okay. And do you recall what that offer was?
It was a state jail felony with time served for criminal neglect homicide.
I mean, negligent homicide. That's correct. So let's go back to interactions. When we first began our court journey, you were set for arraignment after being indicted in December, set for arraignment on January 23rd of 2025. Is that correct?
I don't recall.
Okay. And that would have to be recorded by the court and also have their docket sheets to support that. And we waived arraignment at that point in time, and we set it for pretrial. And at that point in time, you requested that we set it for trial. And that pretrial date was on March 27th of 2025. Is that correct?
I'm not sure.
And would you rely on the court's docket?
Yes, sir, I would.
Okay. And so at that point in time, as we were going through, I explained to you the process of a speedy trial. I explained to you the process of how the court has certain settings, and that we were going through those as quickly as possible to get you to a jury trial. You recall that?
No, sir, I don't.
And it was your request to have a speedy trial. Was it not?
It was, yes, sir.
Okay. And I told you that I had been doing everything in my power to get you that speedy trial, but we still did not have the court's permission to set you on the trial docket. Is that correct?
Something in that order, yes.
Okay. And as I alluded to earlier, when we requested a speedy trial at the docket call setting, judge denied that and set it for jury selection on June 2nd. Is that correct?
Yes.
Okay. And after that, I'm sorry, between the pretrial setting and docket call, I filed several motions on your behalf.
What are we doing here? I mean,
Sir, I'll tell you what you're doing. I'm conducting a hearing on a motion to withdraw as counsel. I've given him the authority to question you. You're gonna answer the questions and you're not gonna be asking the questions. Are we clear?
yes, sir, I am, but.
Okay, that's all I need to hear. Is yes, sir, we're clear. Listen to his questions, answer, and I'll give you a chance to speak, as I've already done. Mr. Manning, please proceed.
Yes, Judge. On between our pretrial setting and May 1st, I filed several motions on your behalf. Is that correct?
I'm not sure.
Okay, and the first motion I filed was an agreed order on bond on April 25th, lowering your bond at your request and by the agreement of the state on on April 25th, 2025. Is that correct?
I guess so, yes.
And judge denied that agreed order on May 2nd, which was our the day after our docket call setting. And I filed a motion to reconsider the denial of that bond as well as the speedy trial motion on May 2nd. Do you recall that?
Yes.
Additionally, I filed discovery of grand jury testimony and other items that you requested in preparation for our trial, and that was filed on May 2nd. Do you recall that as well?
Yes.
Okay. And at our last setting in June 2nd of 2025, judge granted your request for trial and specially sets you on June 9th of 2025. Do you recall that as well?
No, I do not.
And it was after that I got your settings for trial and filed the motions that you requested and the continued negotiations on your case that you refiled your grievance against me. Is that correct?
Yes.
Your Honor, I pass the witness.
Cromwell,
Yes, sir.
go ahead.
I don't know how to conduct in court. I'm not a lawyer, sir.
I'm giving you a chance to speak. You
I don't
interrupt.
I don't know what to say. I mean, I'm distraught here. I mean, I'm not a lawyer, sir. I don't even know what to say. I mean, the only thing I can say is I can pull the grievance if we want to carry on this case. But I mean, it's never taken into consideration my mental state or nothing. You know what I mean? Nothing was. It was always a big joke. That's how I felt with him. And I try to convey to him this right there, and he never makes time to speak to me. That's all I have to say.
Mr. Cromwell, Mr. Manning has asked you several times about numerous times that he's met with you outside of court hearings, and you have either disagreed or said you don't recall. So you're telling me that he's not meeting with you, he's not taking the case seriously, despite all of the testimony you just gave about the numerous times and discussions, and case preparations, and court settings, and bail reductions, and all of these matters. You're saying that he's not taking the case seriously and he's not meeting with you about it?
Sir, when he comes to see us, he sees us 8 people at a time. So we have like 5 minutes each. But I've never been in trouble like this before. I'm in here for a bunch of allegations, sir. I'm not taking it. The stress is bubbling me. I'm stressed out. My mental state is very bad, very bad. The counselor stopped to come see me 2 weeks ago, so I need to speak to somebody. But yes, he's done a little bit of a job for me. Yes, sir, he has. He's done his job. Maybe it's just me that it's not right.
You understand it's hard for Mr. Manning to continue to defend you against the state's allegations if he has to take his time to defend himself against your allegations against him. You understand that?
Yes, sir.
And do you want to know why Mr. Manning's having to ask all these questions today in this hearing that you're frustrated with? It's because you've made allegations against him that could have harmful consequences to his license with the state bar that may prevent him from being able to practice law and support himself and his family. So you understand these are very serious allegations that you've made, and he has to do all that he can to defend himself, just like he's had to do. Despite you making allegations against him, he still has to do his very best to defend the allegations against you.
Yes, sir. I thought the whole deal was to have a client attorney relationship to get it resolved. I thought that was the whole thing. The agreements, when you read it, it says that you put you in a program to get it resolved. I didn't know all this right here was going to be I'm not trying to get him in trouble, no, sir. I know he's a very good lawyer. He's the best lawyer in Benton County. I know this. But when you read the agreements, it says that they put you in a client attorney relationship program to resolve your problems. And I've never been contacted again about the client relationship program.
Do you expect Mr. Manning to have to tell you about the attorney-client relationship program? Is that what you're expecting?
No, sir. No, sir. They said they would write back with it. But I mean, I can pull the grievance. I mean,
Well, the problem is Cromwell is the grievance has already been filed, not one, but two, it sounds like. So that damage has already been done. And it sounds like you have a faulty understanding of the word relationship. Relationship is a two-way street. And I've heard a bunch of, this is the way I feel, this is what I want him to do. I mean, you're wanting to control the way that he meets with you, you want to control when he meets with you, how he meets with you, you don't like that he's seeing other clients at the jail when he meets with you. So, Mr. Manning, I'm gonna grant your motion to withdraw Mr. Cromwell's case. I'm gonna find that Mr. Cromwell is no longer indigent, that he has an asset that's worth $25,000. Therefore, he's no longer deemed indigent. Mr. Cromwell, you're set for trial in February. You need to hire an attorney that you can have a relationship with.
yes, sir.
All right, if there's nothing further, then we're adjourned.
No, he's already said. Judge, I believe that concludes my business. May I be excused.
Yes, thank you, Mr. Manning. Have a good day.
Thank you, Judge.
Say, Graham, anyone else at the jail?
No, Your Honor.
All right, that will conclude court's afternoon criminal docket, and we are adjourned.
Thank you.